Hello, Alison. Nice to see you
Hello.
again.
Likewise.
We're here to continue the series on sex assault cases. This is really geared more towards defense lawyers who are defending against these now very difficult cases, unfortunately, of sex assault. So we had our first episode where we were just talking in general about the pre-trial motions because they're very heavy on pre-trial motions, these types of cases. But today we're going to be focusing on a very important topic, which is preparing for the complainant. So this is really the bulk of the work in a sex
Yes.
assault case. It's really being prepared for the complainant. And you're going to explain to us what you think is an effective way to prepare for the complainant. And we're going to start by covering how to prepare based on the information that we have provided in the disclosure. And then beyond the disclosure, what are some of the things and tools available that we can look at and that could also help us prepare for the complainant? So let's start with the information in the disclosure, Alison. How do we start our preparation?
So at the very beginning, these cases almost always are one based on credibility and reliability
Right.
analysis. So it, an overall tip is just be prepared. Do not wing it. Do not get up there and then just do another chief all over again and help the Crown's case. Don't just sort of meander off the top of your head. These are the sorts of cases that you really want a lot of preparation in advance. So what I do in every single sexual assault case and other cases too in the right
Mhm.
context is I make a chart. So I sit down and I put down essentially every question that is asked by the police, of any import. And then in the next column, the answer that was given by the complainant, and then in the next column, the page reference and the transcript and the line number if you've got it. And I've got that at the ready. So anything that she says in her chief or her cross that's different from what she told the police, I've got it right in front of me. I can immediately just say, pull up, page whatever and take her to the inconsistency. So preparation is absolutely key. You don't want to be, trying to remember if she'd said something different in her statement or, fumbling through all the pages trying to find it. Have it right in front of you. When they're doing their chief, you can sort of be going through it. And if there's things that are consistent, obviously you don't need to ask that again and help the Crown with a prior consistent statement. But anything she says that's different, you've got it right there and you're ready to put it to her right away.
Right. And for this information, we're talking here about the statements that the complainant makes that we can find most of the times in these cases, it's going to be a video interview, but also sometimes in addition to that, there can be a written statement
Yes.
as well. And also pay attention, everyone, to the police notes because sometimes before they start recording the interview, they will have a conversation with the complainant and they will write down notes of what she says. And sometimes there are inconsistencies or there could be some interesting answers in those oral statements that are given to the police. So that's also something that you can still cross-examine them on.
Big time. And sometimes those can be, the police notes of the initial contact with the
Yeah.
complainant. That can be a gold mine because, whether you're being truthful or not, the things you say in the immediate aftermath, when you don't think you're being recorded, they can be very different than what you ultimately say when you sit down in front of the camera in a more formal setting. So those can be a gold mine.
And they can be because as you will, I think you've already noticed that through our clients, people don't seem to realize that what they say is actually a statement and can be used as evidence. I have a lot of clients who always tell me, well, what evidence do the police have? It's all what she said, not realizing that what she says is evidence. If she comes to court and says the exact same thing, that's evidence. So those things that they say to the police that are not in a formal interview setting are still like you can still use that against them. So that's also important to dig into.
Absolutely, yes.
So, what else as well, other than that, that we have in the disclosure that's important to look at and to use for the preparation?
The next thing, and maybe the most important thing and helpful thing in many cases, is the sexual assault kit.
Hmm.
Um, because again, if for anybody who hasn't done one, there's a very lengthy list of questions that's asked by the nurse who's conducting the kit at the hospital,
Yeah.
and it includes all sorts of details about what body part touch what body part, and it's like a 20-page form. And I find when I ask the complainant all of those things, was there digital penetration? Was there, various forms of oral sex, etc.? Um, the answers are often very different than what has been said at the hospital. What the reason for that is, I don't know. Maybe again because they're not talking to the police, they feel a little more at ease, or they don't realize that this could be part of the disclosure. I don't know
Right.
what the reason is, or they're just, overwhelmed by trauma and anxiety. I mean, who knows? But the answers are so often very different. So always rely on the sexual assault kit when you're asking her your questions. I would just go through as a matter of course pretty much every question that's asked that's on the sexual assault
So
kit
do you
form.
re-ask that question?
Exactly.
Okay.
Because those are not, you're not doing the Crown's job for them, because those are questions that aren't really asked by the Crown in Chief. Um, and if the answer is the same as what's on the form, who cares? No harm, no foul. If it's different, then again, you've got something else to put to her that's inconsistent with what she said in court. Um, and then with the sexual assault kit, also at the sort of at last few pages of it, there's diagrams where a nurse will mark
Hmm.
down any injuries
Yeah.
and things like that. Those can often be inconsistent with what the complainant has either described in terms of the events or actually described in terms of the injuries. So the sexual assault kit can be a gold mine. And the same thing with photographs. If photographs are being taken, if she's described, a really violent strangling during the event or whatever, and then you look at photographs and there's, not a scratch, not a bruise, not a nothing,
Yeah.
that again can be really, really helpful in terms of supporting your defense.
Hmm. And but going back to the questions though, that the nurses ask, like, do you even ask the questions even when the answer that is given is not good, and is detrimental?
Yeah, because I don't ever really see a downside. Like if you ask, was there digital penetration, for example, and then this complainant says yes, that's not really harmful, because then you can say, you didn't tell us that 10 minutes ago and you're telling the Crown everything that happened, right? So if new disclosures come out during the course of that, it's a win-win, because they didn't say that in chief, they didn't tell that to the police,
Right.
and all of a sudden I asked you and oh yeah, that happened too. So that's helpful. And then if it's, the answer is no, I mean, who cares? So I don't ever really see a downside to a thorough examination about what's in the sexual assault kit. I mean, obviously, comments that she makes to the nurse about how traumatized she is and that sort of stuff. Yeah, you can leave that out. But
Hmm.
in terms of the actual events and injuries, it's a gold mine.
Okay. And Allison, in addition to the sexual assault kit, we often see other type of evidence in these types of cases, and that's the clothing, or
Mhm.
sometimes, like most of the time, especially, I mean, when there's like some serious sexual, when it's not just touching and kissing,
Right.
the underwear and
Yeah.
clothing is going to be provided to the police.
Yeah.
So, how does a defense lawyer prepare with that evidence?
I find that evidence in terms of the actual physical clothing evidence not ever particularly helpful.
Hmm.
Um, you know well in advance if there's DNA on, I mean, anywhere, the swabs from the hospital or the clothing. And so you've already factored that into your defense and how you're going to approach it. So that's not really a surprise. And your defense, one would hope, is not going to be inconsistent with that physical evidence, because
Yeah.
you've prepared with your client, you've had him explain how that's possible. So I tend not to really spend much of any time on that stuff, because
Hmm.
there's nothing really to challenge the complainant with for the most part. I mean, other than, again, if she describes let's say some sort of injury that one would have expected to see blood on clothing or something like that, then you can, ask her about that and suggest that there's no blood and therefore that didn't happen. But for the most part, I don't really spend much of any time on the physical evidence because there's no gotchas there.
And especially, I mean, in cases where consent is the issue. I mean, whether there was sexual activity or not, like
Exactly.
that's not going to be a problem
Right.
because the accused is not denying that.
Exactly.
But our clients will just, I mean, the DNA doesn't say anything about consent. It's more
Exactly.
problematic when the client is saying, well, nothing happened, but then there is some kind of DNA suggestion that, yes, he's a match, he's a
Oh
potential
yes.
match.
The DNA just
So,
got up and walked across the
yeah,
hall in the middle of the
so
night and somehow found its way on her
so
clothes. Yeah.
that could be problematic, and we'll get maybe
Huge.
more into that when we're dealing with the client and preparing
Yeah.
the client for that. But that's also part of the evidence that we can have. Now, other types of evidence that we have more and more of in these cases are the text messages, but
Mhm.
there are also sometimes videos, surveillance videos of them. Let's say if it's in a hotel or in somewhere they're going to a place and that's when the incident takes place. We have videos, CCTV footage of them going into the place. So how do we use that evidence?
Video, as we just saw in the Hockey Canada trial, can be
Yeah.
very, very helpful.
Yeah.
The surveillance video was an enormous factor in it.
Right.
So, again, if you do have surveillance video, look at it from the standpoint of what the complainant described in her statement to the police, and look for any differences. That was really to the complainant's detriment in the Hockey Canada
Yeah.
trial. She um, would describe, for example, not dancing with any of the guys, and then you see the video and they're,
Yeah.
dancing with all nine of them at once, or whatever.
Yeah.
So the video can be really, really helpful.
Hmm.
Um, and text messages will save the problems that can raise for our clients
Yeah.
for another day. But um, sometimes you'll see, for example, text messages, not with the accused. I mean, those can be helpful, but with, friends, her first disclosure to, her friend or her mom or her whatever. Um, and she provides those to the police. And again, you'll find a different, sometimes, version of events in her description via text to whomever afterwards. Um, Sometimes there'll be text messages, the morning after to the accused, where, it's all lovey-dovey or I can't wait to see you again or,
Yeah.
whatever, something like that. And, we have to be careful what we ask a judge to make of that because we know about, trauma
Yeah.
reactions and that sort of thing. But it's certainly worth exploring. If she says, I never spoke to him again, I was, blocked him immediately, that sort of thing, and you've got text messages suggesting otherwise. That can be helpful. Sometimes it's the absence of text messages that's helpful.
Hmm.
I find very often complainants or witnesses will talk about text exchanges that they had with the accused about whatever, before, after, during, and she testifies about them. Yes, I confronted him via text, or he was being creepy via text, or whatever. There's no text in the disclosure. And so I say, well, surely you provided those to the police, isn't that right, ma'am? Well, no, I didn't. And that's a red flag for judges, right? If you've got these really important text messages that you're testifying about and never bothered to give them to the police, that casts some doubt potentially on your credibility. So it's not just the text messages you get in disclosure, but sometimes the absence of them that can be really, really helpful.
And can we just talk a little bit more about the text messages that are exchanged just before the incident? Because
Mhm.
that sometimes gives us an idea, or this is what our clients will say, well, this is the intention. That is how they get the clue that she wants to meet them, let's say, to have sex, especially
Yep.
in a context where the defense is, well, she wanted to do this. Like, why is she complaining now that it was a sex assault? And usually they're relying on the exchange that happened just before, but then they will say, the complainant will say, no, I never said that. So those those are sometimes the more problematic text messages. So how do we deal with those ones?
And those, that was always a very tricky area because I had a case just very recently where the complainant and the accused were texting basically about all the things they wanted to do to each other
Yeah,
sexually when they went out on this
yeah,
date. And I brought a 278 in this case to try and have those admitted so that I could ask the complainant about
yeah.
them, and it was denied. And then came out a very recent Supreme Court case that says, wait a minute, those can actually be quite relevant.
Yeah.
Yes, you can't consent in advance, but if there's text messages or conversations discussing the particular event in question in advance, that can be probative of consent. So, yeah, those can sometimes be very, very helpful. And
Uh,
always cross-examine about any inconsistency.
all right. So, in addition then to the information, this is here we try to cover the main elements of disclosure that we have. But sometimes there's information that can be very useful to cross-examine the complainant that is not in the disclosure. So sometimes you have to also go beyond the disclosure to get some relevant information for cross-examination. So let's get into that, Alison. What are some of the other areas beyond disclosure that you would suggest that people really pay attention to? Oh, sorry, your voice is not very clear.
I'll just let my mic cool off for a minute there.
You're on mute? I think you're on mute.
I'm not. Sometimes my audio cuts out. Let me just switch devices. Can you edit out this like short clip?
Yeah.
Okay.
All right. So, yes. So, about the other areas or other elements beyond the disclosure that we should be looking at and that could be helpful on cross-examination of the complainant.
Yeah, the two things that you should always consider are one, her social media accounts, and two, a private investigator. There
Mhm.
are cases where it's going to be very beneficial to retain a private investigator. And in terms of social media, I mean, it was better back in the day when there weren't as many privacy settings, let me tell you, where Facebook was a gold mine. Now there's, a few safeguards out there, but it can be a gold mine in terms of things that the complainant will say and post on social media versus what she says in court. So I would always be a social media stalker. It is well worth the time to try and track her down on social media. And a private investigator, with the right facts, can be really helpful. I just retained one recently in a case where, long story short, a woman, the the accused and the complainant are colleagues at work. And the complainant had told the accused, according to him, that she was single. They go out to a work function, they end up at a hotel, the rest is history. Um, I hired a private investigator because, he had heard through the grapevine that maybe she wasn't actually single and that might have been a motive to fabricate. So I hired a private investigator. Turns out she's married. Um, and so we now have a very strong motive to fabricate to present at trial. So a private investigator, it's not going to be, necessary or the right thing to do in every case, but it really can be helpful. If you have, for example, a strong theory of a motive to fabricate or, information that things that she told the police of some nature might be untrue, a private investigator can be worth the investment. And they're not that costly for the most part.
Okay. Yes, and that's going to be important for the clients who can't afford to pay a lot of money,
Yeah.
so they can find a private investigator that they can retain at a reasonable rate. But
Yes.
going back a little bit to the social media, so what from examples of cases, what is some of the scenarios or the information that could be relevant and important to cross-examine a complainant about?
I mean, for example, a couple that I've had fairly recently, one of them was the complainant testified that she was uh, severely injured essentially from this interaction with the complainant or with the accused, and the accused said, "That's ridiculous. No, she wasn't. She was, out dancing the next day." He didn't say that part, but he strongly
Yeah.
disagreed. And lo and behold, I go and check her Facebook account. And the very day after this alleged event had occurred, it was a more historic reporting. It was like a year or something afterwards. There was pictures of her doing snow angels out in a park somewhere near her house. Clearly was not injured
Yeah.
and unable to get off the couch like she had told the police that she was. So that was fantastic.
Yeah.
Yeah, I mean, I forget what the second example I was going to give was, but that was, you don't usually have the gotcha moments. That was an actual gotcha moment in court. So you know, y- you'll when you're watching her statement, you'll think of things like in this social media age, you sort of get triggered in your head of things that you might find evidence to the contrary of on social media. So um, keep that in the back of your mind when you're watching her statement.
And I think that sometimes it can tell you also about the complainant's personality, or if it's
Mhm.
someone who has had some previous traumas, or
Mhm.
I mean, it can also, or if they've complained about someone before, like if they have a tendency of reporting that kind of stuff. I mean, sometimes it's just digging into what they've done in the past. Is this
Yeah.
something that they've done before, or is this the first time, or is this unusual? So that could also help. And obviously, every case is different.
Yes.
I mean, social media can be helpful in one way in one case, but completely different, helpful in a different way in another case. Uh,
Totally. And people tend to be um, really open books on social media, for
yeah.
better or for worse. So always, always stalk her social media.
So, is there anything else, Alison, beyond the information gathering that obviously this is going to be the main
Mhm.
elements that we're going to rely on for cross-examination? It's the
Yeah.
information that we have in the disclosure, what we can find out that could potentially be relevant. But what else as well do we need to be? Maybe if we can talk a little bit about the tone to use, because in these types of cases, we're asking people questions about a very, very private
Yes.
moment, very embarrassing. And we know that judges tend to kind of want to be more gentle with these complainants in particular, which is
Yes.
difficult because we want to ask difficult questions. And there's this balancing that has to happen
Yes.
between you having to ask the difficult, very private, very intrusive question, but also in a way that is not disrespectful still to the complainant. So if we can talk a little bit about the tone in court,
Agreed. Yeah.
and also because maybe a difference between a judge alone trial versus when it's a jury trial, because that's also going to be very different.
Yeah, and it is in many respects, but when it comes to the tone of the cross-examination, I think it's actually very similar. You're exactly right. You do not, there's always going to be exceptions to the rule, right?
Mhm.
When you can prove beyond any shadow of a doubt that someone is lying and fabricated something for whatever ulterior motive. But those cases are few and far between. Um, Usually at the end of the day, you really don't know what happened. There's only
Yeah,
two people in a room.
right.
And I always, my philosophy tends to be that even if the complainant is wrong, um, lying, whatever about what happened that night, there's some trauma or some reason that she's saying what she's saying.
Hmm.
And you should always, with very few exceptions, I think, be sensitive. It's sexual assault is not the case where you're, slamming your pen down and pointing your finger and
Yeah.
being aggressive. Because whatever the reason she's there, whether because she actually is a victim or because she's been through something else that caused her to make these allegations, um, she's been through something.
Hmm.
90, 99 times out of 100. And re-traumatizing a complainant is never going to win you points with the
Yeah.
judge. It is never going to win you points with the jury. You can get all of your points across. You can be just as thorough and detailed, but do it in a sensitive manner. Um, and things as simple as if the complainant is, tearing up
Yeah.
or whatever, asking her, do you need a break? Like be sensitive.
Human. Yeah.
Exactly. You don't have to be a dink.
Yeah.
Be sensitive. You can still be just as effective. Um, and the judge and or jury will appreciate you doing it in a respectful way.
Okay, yeah. And that's really something to be very mindful of here in
Yeah,
these types of cases. Also, maybe a bit in domestic cases as well.
exactly.
They're very similar in that sense. So it's not the type of case where it's a good idea to be aggressive with
Ex-
the complainant,
Same
especially
and
now.
same for children, right? Any cases
Exactly,
involving
yeah.
children. You're not going to stand up there and yell at a child and expect to win any favor with the judge.
Right. And that's an important point because in many cases, unfortunately, the sexual interference cases, we are going to be dealing with very young complainants.
Yeah.
And it's very important as well to know how to address them. And I find with the appropriate tone, actually, you can get a lot more information in your favor from that adverse witness
100%. Yes,
than
they think you're their friend.
yeah,
And you get a conversation going as
yeah,
friends and man, the things that you can get out that
yeah,
way. I couldn't agree more.
yeah. All right. Is there anything else, some final thoughts or points that you wanted to make on the complainant preparation?
Only just going back to the last episode.
Yes.
You should, I think, in most cases, canvas because you haven't had a prelim since somebody thought it was a good idea to take those away. Ask about, whether she's ever been to a doctor as a result of something that occurred with the accused, if she's got any diaries about it, if she's had any therapy, talk to a therapist about it. If she says yes to any of those things, 278, stop
Hmm.
the trial, bring an application. Um, and not only can that result in, again, another gold mine of information that may be inconsistent with what she's testified to. But also in some cases, when these are things that could have, maybe not could have, but should have been discovered by the police or provided by the complainant, sometimes it can provide the foundation for 11B application
Yeah.
in the right circumstances. So I would always canvass if there may be records out there that would be worth pursuing. And leaving aside, whatever you might get out of any records application mid-trial, again, you go back to, if there is some sort of record out there that one might think the complainant would have thought to provide to the police and didn't, that can go to her credibility as well. So um, always spend a few minutes, at the beginning or the end, just canvassing those things. It's if she says no, none of those things existed, it's of no detriment to your client. It's well worth asking.
Well, and also sometimes what's important, the presence of something can be good or bad, but also the absence of something is also important because there are some things that you would expect to be there, and if they're
Yeah.
not, well, that also is important information and an important question to be that we need to get an answer for.
Exactly. Yeah. Like if there's any, injuries, for example, that she describes or lasting injuries and, she'd never been to a doctor once or, yeah, I had a few cases where either in the domestic context or the sexual assault context where you ask about, well, surely then since you got X injury, you went to see a doctor and the complainant sort of caught off guard and says, well, yes, of course I did. Thinking, oh God, I better agree with that. And then you go and subpoena records from that particular doctor. Turns out there was never any visit. She'd never been there. I've had that happen in a few times,
Hmm.
a few cases. So the absence of records is just as important sometimes as the presence of them.
And also the absence of injuries when the allegation is that it was a brutal and violent sexual assault, then and
Yeah,
there are no injuries, then the question is, well, how how can this be if, the description is that it was very violent, it was
exactly.
a
Yeah,
rough act.
yeah.
Okay. All right. So I guess that's all for today, and we will be continuing this series. Thank you, Allison.
Nice to see you.
Nice to see you too.